I have to admit that it is hard for me to picture Larry Walker in retirement. Larry and Sharon do not look a day older than when I arrived here to Charlottesville 21 years ago. And Larry remains an energetic and enthusiastic teacher, scholar, and participant in the intellectual life of the law school. In fact, I think of Larry in much the same way as I do his colleague Glenn Robinson. Regardless of chronological age, they are always intellectually in their prime. Larry is a native of South Carolina who gradually worked his way north to Virginia. He graduated from Davidson College in 1959 and from Duke Law School in 1963. After law school, he served in the Army, practiced law in Atlanta, and served as counsel to the Senate Judiciary Committee. He received an SJD degree from Harvard to prepare himself for an academic career. Now, Larry tells me he had his eyes on Virginia right from the start. It turns out that he had a preliminary interview here with Walter Wadlington, whom Larry remembers being dressed in white from head to toe during the interview. I assume it was before Labor Day. He also spoke to Emerson Spees, who said, with his characteristic combination of charm and directness, that perhaps it would be better for Larry to gain a little experience at another law school first. So Larry began his academic career at the University of North Carolina Law School. Larry taught civil procedure there, among other things, and like many teachers of that subject, routinely explained to students the logic behind particular procedural rules with reference to widely shared assumptions about human psychology and behavior. But he found himself wondering why lawyers took those assumptions to be true. That led him to seek out John Thibault, a social psychologist at UNC, whose research focused on perceptions of fairness. They set out together to study the fairness of legal procedures not from the standpoint of moral theory or intuition, but as it was perceived by the parties to an actual dispute. In doing so, Larry can fairly be called one of the pioneers of the use of experimental methods in law. Theirs was interdisciplinary research at its finest, making important contributions both to law and psychology. At that time, research on perceptions of fairness in psychology focused almost entirely on the distribution of resources and perceptions about the fairness of that distribution. Thibault and Walker offered a rich vein of research by turning attention to subjects' perceptions of the fairness by the procedure by which a distribution was reached. Their research was part of a revolution in social psychology that affected not only thinking about law, but thinking about business and public policy, among other things. The work was no less revolutionary for law schools. In the 1970s, law and social science meant law and economics, and law and economics meant the microeconomic analysis of legal doctrine. Thibault and Walker's work, by contrast, drew on psychology and used empirical methods to test theory rather than using theory to explain doctrine. One of their early experiments involved the resolution of a simulated dispute between experimental subjects. They compared two dispute resolution procedures, one adversarial in the style of Anglo-American law, and one inquisitorial in the style of continental European law. They found that subjects perceived the adversarial system, which gives more control over dispute resolution to the parties themselves, as more fair than the inquisitorial system. Later work found that experimental subjects were more likely to conclude that the substantive outcome of litigation was fair when they had already concluded that the procedure by which the litigation would be resolved was fair. Larry's success in the classroom and as a researcher led to an offer to visit here and ultimately to join our faculty. Even then, Larry had to run the gauntlet of another session with Emerson Spees. Emerson asked him, "Are you a tennis player?" To which Larry gave the correct answer. Emerson followed up with, "Are you an A player or a B player?" Larry opted for honesty and replied, "I'm a B player." Emerson said, "Well, then you won't be playing with me." But Larry did get the job. Shortly after Larry's arrival, the law school took a bit of a gamble and became the first American law school to hire a non-lawyer psychologist as a full-time member of the faculty. John Monahan, who is with us today, was that psychologist, and his hire was a testament to the law school's strong emphasis on interdisciplinary research. It also gave Larry the opportunity to continue collaborating with an outstanding psychologist. This began a long and productive partnership that has produced some of the most influential and thoughtful scholarship on law and social science methods ever written, a collaboration that Larry has identified as the highlight of his professional career. John and Larry's first project was a casebook, Social Science in Law, the first of its kind, published in 1985 and still widely used today. I didn't realize it was also used by the president of our university in its 6th edition. The Casebook project forced them to think broadly and systematically about the use of social science research in legal disputes. John and Larry concluded that social science was used in litigation for 3 basic purposes. The first 2 were not novel. Social science methods could be used to establish case-specific facts, and social science methods could be used as a source of authority that would then inform doctrine as it was used by judges. The third use, however, was novel. They noted that social science research is often used as a framework, as they put it, to guide a court in determining facts. For example, research into the accuracy of visual memory can help a fact finder decide how much weight to assign to an eyewitness's testimony about a subject's clothing or height. This taxonomy of the use of social science research shaped John and Larry's research agenda for several years and produced a series of articles that to this day inform the use of social science in litigation. They then turned to a number of discrete problems of social science methodology within law. To his faculty colleagues, Larry's infectious good humor and openness have been as important as his intellectual contributions. Larry's boisterous, exuberant laugh communicates uninhibited pleasure and has rung frequently through these halls for the last 33 years. He is as wonderful a friend as he is a colleague. He and Sharon have been a delightful presence in the life of this law school. Larry and Sharon gave the law school the greatest vote of confidence a person can bestow by encouraging their daughter Helgi to attend. Not surprisingly, she was an absolute star at the law school and went on to clerk for Judge Wilkinson on the Fourth Circuit and then for Justice Thomas on the Supreme Court. The excitement Larry's colleagues felt in seeing our students succeed at such a high level was multiplied many times over because of Larry's visible pride and delight. Larry, I hope we will continue to see much of you and Sharon. I have a small token of our affection and invite you to say a few words to our graduates.
Paul, thank you very much for that comprehensive introduction. I want to spend my time thanking a few very important folks to me. First of all, I'd like to ask my wife Sharon to stand so that I could express operating on the wise man's statement that showing up is the most important thing. Any success here starts with Sharon, who got me out of the house and over here on a pretty regular basis. And I also want to introduce you to my 25-year-long partner, who's John. Where are you? John Monahan. John. John pretty well solved the problem of what to do when I got here, and as I stand, it was in this very place that I heard one of our alumni advise students about careers in law, and he said the most important thing is to choose good partners, and the rest takes care of itself. So I'm pretty much in John's debt for that. The third is I want to thank the alumni, because you are the folks that make the difference here. I think it was Hardy Dillard that said the alumni and the foundation are the margin of excellence. This school wouldn't be what it is, which is a great American law school, without the support. You do make the difference. You have made a difference in my life. You've made it possible for me to stay here and enjoy it, enjoy every minute. So I express my appreciation, and I'm sure that of the entire faculty. The last person I want to thank is Dean Mahoney. Congratulate him on several years of outstanding leadership. And I do want to say that he is just one of a line. I have worked here during my whole career with the finest law school leadership over time in America. It began with Emerson Spees. There were many wonderful folks along the way, including Richard Merrill, John Jeffries, Tom Jackson, Bob Scott, all really remarkable folks. That's crucial in the operation of a law school, because we have had the confidence in our deans, and it means that the faculty can go about its business. I was trying to think about this year, and I don't believe that we have needed, except for formal requirements, to have any votes in our faculty meetings. And we have gone a number of other years with such a degree of strong leadership and agreement among the faculty that we have avoided any incivility, virtually any dispute, and therefore run a highly reactive and enormously efficient law school. So I thank Paul as a representative of some of the finest leadership I've ever seen. Thank you for being here. Thank you for your support. Thank you very much.